trust the old technology, Lord. I want to start by talking to you about what this case is not about. This case is not about the actions of Charmaine Turner on July 4th, 2020. Not about money. This case is not about the decisions that Omar Ivory was forced to make. It's not about the man behind the wheel. And ladies and gentlemen, this case is not about 2 plus 2, 4 plus 4. It's not about that. It is not about the mother, the man behind the wheel, or Matt. Ladies and gentlemen, this case is about the intentional and the deliberate and conscious decisions that this defendant made as he wielded his AR-15 on a public road in York County, ladies and gentlemen, on July 4th of 2020. That's what this case is about. That's why we're here. We are here because of what he did on July 4th, 2020. What he did to an 8-year-old little girl. What he did to 8-year-old Secoriea Turner. The day that he ended her short 8 years of life. What we did learn during the course of this trial, we learned that Secoriea loved to dance. We learned that Secoriea loved to read. We learned that Secoriea loved to learn. And she had already made a decision she wanted to go to spelling. We learned all of those things from her mother as she sat before each and every one of you and told her about the worst, the absolute worst moments of her life. She told you and sat here and explained in great detail every parent's worst nightmare. The most unnatural thing in life. She sat before each and every one of you and explained to you all the facts and the circumstances that she experienced in that absolutely terrible moment in her life as she sat before each and every one of you last week. When Charmaine was testifying, she talked to you about how much Secoriea loved her brothers, how much she loved playing with her cousins. And she said something while she was testifying that caught my attention, that I'll never forget. She said she just loved to love. She just loved to love. And this defendant on July 4th took that love away from this world, took that love away from Charmaine. But as she testified, she talked to you about the last moments of Secoria's life. And I hadn't caught it, I hadn't heard it until she sat before all of us and explained to each and every one of us what she felt, what she remembered, and what happened in that car on July 4th of 2020. But when she was testifying, when she was talking to each and every one of you about the last moments of little Secoria's life, she said she didn't talk. She just looked into her mother's eyes. She just caught her eyes and gazed into her mother's eyes. In the last moments of her life, Charmaine was describing Secoriea still trying to provide that love, that comfort to her mother. And this defendant on July 4th of 2020 shut that light off. Made it so the joy that Secoria's family felt every single moment that they were around her was gone. But Charmaine made very clear that Secoria's memory will live on, that they created a scholarship at Spelman in her name, and that he may have taken her from this world, but he can't take her memory. Her light will always shine on the things that were most important to her. And that was clear from the testimony of Charmaine. That was her family. Now, I want to talk to you over the next 25, 30 minutes about some of the law that the judge is going to explain to you at the end of the trial. And the law that you're going to apply to all the facts and all the evidence that you've heard this week, and feels like more than a week ago. I can at least say it for me. But I want to start with talking to you about your duty, a juror's duty. And your duty is just plain and simple. Be a fair, impartial juror, honestly seeking the truth. You're not to seek doubt. You're here to weigh the facts and weigh the evidence and make a decision. It's kind of what we talked to you about when we started the process. It's exactly what we did. We asked you questions, you gave us answers. We asked you some more prying questions, and you gave us answers. And that's how we were able to determine that you, ladies and gentlemen, were the right people for this job. That you could listen to all the facts, that you could listen to all the evidence, and be fair and impartial, and seek the truth of what happened on July 4th of 2020 when Secoriea Turner was killed. Now, again, it's to seek the truth, you're to follow the law that the judge is going to give to you, and you're to deliberate. And we say that, the deliberate part, I know it sounds incredibly obvious, but there have been times in the past where jurors forget that they're supposed to deliberate, and one or two may decide that they don't want to partake in the proceedings. So we just tell you that so you're aware that that does happen, and I don't think it will, but if it ever does, that's something you just bring to the court's attention, and it'll be addressed. You just seek the truth according to the evidence. You are to determine the facts of the case based on what was presented to you over the course of the last 2 weeks. All of the evidence in the form of photographs, videos, testimony that you heard from the witnesses here at this witness stand, and up in the courtroom, it sounds like, with the bigger jury room, that first day that we started a trial. Now, what you're not to consider, you're not to consider passion. You're not to consider public opinion. Whether you are unhappy or like the performance of the police here or in your past. Public feeling and sentiment as it relates to social issues that we've heard a little bit about over the last 2 weeks. Sympathy for the defendant, sympathy for Secoriea's family. Whether you disagree with the law, conjecture. You are not to consider penalty or punishment. That's for the judge. And any prejudice you may have. You leave that outside of the deliberation room. And what you are to consider and what you are to use as tools to apply to the evidence and the facts and the testimony that you've heard is obviously the law, the testimony of all the witnesses that you heard and your recollection and reviewing your notes, admitted evidence that you will receive at the end of this trial, the elements of the crime, which you'll learn about here shortly from the parties and from the judge, expert witness testimony, physical evidence, and as we all talked about on Monday 2 weeks ago, your common sense and your life experience. You use all of that when you are cycling through and remembering and looking through your notes about the facts and the evidence and the testimony that's come out over the course of this trial. Now, you heard a little bit about this at the beginning of the trial, about whether you can hold the state to its burden of proof. And that burden of proof, it rests with the state. It never leaves the table. The burden of proof is always with this side. The burden is for the state to prove beyond a reasonable doubt each and every material allegation, each and every element of every crime in the indictment that you painstakingly heard me read the first day we started the trial. Now, the judge is going to talk to you about each and every defendant. This defendant, when we started this trial, had a presumption of innocence. Every defendant who exercises his constitutional right to a trial has this presumption of innocence. And I like to kind of compare it to a cloak or a jacket. So he walked in on the day we started trial with a suit coat on, with the presumption of innocence. And as the facts and the testimony unfolded, as witnesses testified, as the video from every angle was shown to Detective Shepard, it started getting warmer in this room, and it was pretty warm throughout this trial. But as the evidence and the facts and the testimony continued to come out, that cloak came off. That cloak of innocence went goodbye. Because the state proved, when we rested beyond a reasonable doubt, that this defendant is guilty of each and every count in this indictment. Now, you're going to hear a lot about reasonable doubt, what it means, and a bunch of lawyer jargon. We lawyers tend to use words that should be easy to understand, then we take them and garble them and make them pretty complicated. So reasonable doubt means just what it says, reasonable. It's based on your common sense, your reason, your life experience. It doesn't mean an arbitrary or vague doubt. It's a doubt in which you can give a reason. It's a doubt in which is reasonable. Now, the state's not required to prove the guilt of the defendant beyond all doubt, beyond a mathematical certainty. There's no equation involved, because the only equation that's involved in this trial, any way that you put it, if you do 2 plus 2, 4 plus 4, whatever it may be, they all equal -1. They all equal -1. Because no matter how you look at it, and how you put the facts and the circumstances together, Secoria's gone. She's not coming back. That's the equation that's important in this trial. Reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. Again, you're not going to seek doubt. What does that mean? Apply your life experiences, apply your common sense to what you heard over the last 2 weeks, and that's how you come to your decision. That's what you do back in the deliberation room. The only difference is once the trial ends, once the judge finishes the charge, you guys are in the driver's seat. You don't have to wait on us. There's no breaks because of any conversations that the attorneys have to have, or any sidebars for the judge. You guys are in control, and you guys get to apply all of your life experiences to everything you've heard over the course of this trial. The judge is going to talk to you about the different types of evidence, but there's direct and circumstantial evidence, and she's going to explain to you what each one of those is. It's fairly obvious. Direct evidence is evidence that points immediately to a question at issue. So it's evidence that's tangible. It's photographs. It's the videos. It's documents. It's testimony that you heard from witnesses as to what they saw, what they heard, what they remembered seeing and hearing on July 4th, 2020. She's also going to talk to you about circumstantial evidence. But as it relates to direct evidence, again, not the 911 calls that you heard, things of that nature. What Omar and Ms. Charmaine were called, and how they were able to remember and talk to you about the 911 call that was made that night, and the people they remember seeing surrounding them as they passed the barricades. Circumstantial evidence is proof of facts or circumstances by direct evidence, which you may infer other related or connected facts that are reasonable and justified, again, in light of your life experience. Now, I like to provide an example I think we all have experienced in life, an everyday experience. So, when I'm one of 4 children, I have a twin sister, I have a brother who is 16 months younger than me, and then I had a brother who was 6 years younger than me. So my mom had her hands full throughout the years that she was raising us. Now, before my youngest brother was born, it was almost as if my sister, my brother, and myself were triplets, because we were very close in age, and we were pretty wild. So we injured ourselves quite often. And so we were either in the ER, doctor's office, whatever it may be, with a broken arm, busted leg, busted lip, something that needed to be patched up. Now, if you use what we just talked about, direct and circumstantial evidence. Circumstantially, if you don't know anything about the facts and circumstances, you see my mom bringing all 3 of her children to the hospital or to the doctors injured. And you may draw some inferences based on what you just see, not knowing any of the context or the details. Now, what's interesting is as the doctors would speak to each one of us children, as they would treat each one of our injuries, what they were able to see directly from speaking to us, the injured parties, and my mom, who unfortunately for her was an eyewitness to most of our injuries, was that we were crazy 3 kids who couldn't sit still and liked to have fun. And so that's how I like to explain direct and circumstantial evidence and how you apply it and use it. And what the doctors would say beyond a reasonable doubt, after we leave, after each visit, that we be back, and that my mom had the patience of saying. So that's how you use your life experiences to use direct evidence and circumstantial evidence to come to a conclusion. Exactly what you're going to have to do when you are looking at the facts and the testimony of this case. The judge is also going to tell you that the testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there's no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. Now, this is a great example of this. You heard from Mr. Christopher McCord. He testified about his experiences in the community, how long he had lived in that area near Pryor and University, and his experience on July 4th when he approached the barricade, and what he remembered, and how he remembered that 2 people specifically, one had a shotgun, another had a long rifle, and pointed it in his face to him and his wife as they attempted to pass through. Now they were able to turn around after Mr. McCord had an exchange of words with who he later identified as the defendant, Detective Shepard, when he told Detective Shepard that the individual he saw on the news conference was the person who pointed that AR-style rifle at his face when he first encountered the barricades. And Mr. McCord's testimony, Mr. McCord's recollection, is further corroborated by the video evidence that you saw painstakingly over and over and over again over the course of this trial. You see this defendant in his very distinctive clothes with his AR-style rifle doing some sort of, looked like military move, pointing a weapon in the direction of both Mr. and Mrs. McCord, looking as if he's about to engage their vehicle with his AR-15. You are also going to hear about how you're to judge the credibility of witnesses like Mr. McCord, how you're to judge the credibility of Detective Shepard, and how Detective Shepard explained to you the process in which he took and how he worked backwards after he got all of the video tracking the defendant because of his distinctive clothing in each one of the videos and each one of the angles in order to place him exactly where he told you and where this defendant is at the time that the Jeep Secoriea is traveling and passes the barricade, at the time that Secoriea is shot in the back. The judge is also going to talk to you about statements that you heard previously. It's not a secret. This case is not a case that occurred yesterday. It's a case that occurred in July of 2020. As your common sense will tell you, memories fade. That's why things are recorded and things of that nature. That's why you heard about reports and prior statements that were made and talked about during the testimony of this case. Now, the judge is also going to talk to you about identification. And identity is a question of fact for you, ladies and gentlemen, to determine. Your determination of identity is dependent upon the credibility of witnesses or witnesses offered for this purpose. You should consider all the factors previously charged about credibility, which you'll hear about again from the judge at the end of the trial, and the factors you would apply, and the ones we just talked about. And a great way to kind of boil this down is the books when we were kids, the Where's Waldo book. And, at first, you'd flip through each page, you'd look for wherever Waldo was, but once you found him, you never couldn't find him again. That's exactly what we have here. And that's exactly what Detective Shepard explained to you, and that's exactly what you saw as it relates to this defendant's distinctive clothing And once you know where he is, what he's by, and when he's at the barricade, you can then use the contextual clues that you've learned from your previous experience of seeing where the defendant is, what he's wearing, and how he looks. And then you never lose him. And that's exactly what Detective Shepard described. And this is exactly who Detective Shepard first saw in the Martyr video. In photographs during the day prior to being seen in the Martyr video, in the exact same clothing, with the exact same satchel, the exact same gun, same photos, Bolo. The defendant's photo from his license, and the defendant on the day that he did his press conference, and provided you the statements that he did along with his counsel that referenced his recollection based on not knowing what was eventually found on the video. That statement was made by this defendant and his counsel before he knew there was more than Bolo photos from a Martyr video. Before he knew that Detective Shepard had been able to pull video footage from the all-package liquor store, that he was able to pull footage from the BP gas station, and that he was able to pull footage from the 2 cameras at the warehouse, and that he was able to track the defendant's every move as that car approached the barricade. So when he did this press conference, the distinctive outfit was nothing to him. It was just a gang advertisement for the pirate gangs. He didn't know that Detective Shepard was able to track that red shirt with this distinctive red lettering in each one of the cameras that he described to you. Now I want to talk to you about parties to a crime. And we referenced aspects or parts of this during voir dire or jury selection. We're going to talk to you about this. And the judge is going to tell you that every party to a crime may be charged with and convicted of the commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps the commission of the crime, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. The judge is also going to tell you about, and you heard when we read the indictment, about Jerry McKinney. And the reason this slide is up here, and the reason this chart is given to you, is that you're not to consider Mr. McKinney and his case and what's going on with it. You're just to consider the evidence that you heard and his role that he played and how he worked in conjunction with this defendant. That's what's important to your analysis, ladies and gentlemen. That's what is important as you view and go through the evidence and remember the testimony. It's the role that Mr. McKinney played and how he worked with this defendant. You're not to consider or worry about what's going on with this case, because his case is for another day and for another jury. Now, you also heard from Detective Shepard about parties to a crime. He gave you an example involving a bank robbery. And I'm sure each one of you remember the example he gave and how he gave it, and the importance it plays in providing an example as to basically the actions of one are the actions of all as you work together. And the way I like to think about it and describe is kind of a team sports example. My brother played football at Wake Forest back when the one season that they were pretty good. They'd gone to the Orange Bowl, and I went to every one of his games. It was a great experience to watch somebody who you care about succeed on such a high level. And why it's something that I am able to utilize when I'm talking to people like you, ladies and gentlemen, is because in a sport like football, it's every player has a role. You've got the quarterback, you've got the defense, the offense, things of that nature. And no matter if the quarterback throws an 80-yard pass and a touchdown occurs, 7 points go on the board, it's not 7 points for the quarterback. It's not 7 points for the person who caught it. It's 7 points for the team. Here it was the Demon Deacons. So everyone has to play a role in order for the end goal to occur. And when the end goal occurs or a failure occurs, the entire team accepts the goal or gets to succeed and celebrate, or not, but together. It's not just the quarterback getting the 7 points or the running back getting the 7 points. It's the whole team, or it's the whole team losing. So everyone plays a role in order to get to the end process, in order to get to the win, or in order to incur the loss. The judge is also going to talk to you about conspiracy, and it's very much kind of like parties to a crime. So conspiracy means an agreement between at least 2 people to commit an unlawful act. That agreement does not have to be something where you shake hands and a verbal of nature. It can be shown through conduct and presence of the parties involved. The presence, companionship, and conduct before and after the commission of the alleged offense may be considered in your determining whether circumstances arise to the point where you think a conspiracy exists. And what does that mean? It basically just means that the things that you do before, during, and after, the actions that people see, the fact that this defendant and the members of his gang and friends showed up to the barricades, worked in tandem as a team to prevent citizens like you, ladies and gentlemen, from traveling down University and Pryor. And at times when people didn't submit to that authority, when people asserted their own independence on July 4th, they were met with threats and they were met with violence, and Secoriea was met with the ultimate violence. She paid the ultimate price for the lack of submission to their authority. Like I said, the agreement may be expressed, meaning it can be written, things of that nature, but it also can be an unspoken understanding. It can be a group of people, as we heard yesterday, at times, all showed up for the same cause, all did similar, the same actions in the sense that they didn't have an agreement where they wrote down on a piece of paper they were going to not let people pass through the barricade, but the unspoken understanding was the fact that they all participated and didn't let people go through the barricades, and there were consequences that they all worked together to provide to individuals who didn't assert to their authority, to individuals who didn't submit to their dominance. What the evidence showed during the last 2 weeks was that this defendant and his other co-conspirators, named and unnamed, known and unknown, through their actions, their words, both had an agreement to participate in a legal barricade. When they did that, they refused to allow citizens to travel through a university in Pryor. And if anyone attempted to disrespect them, if anyone attempted to travel through those barricades, they were met with violence. That's what we saw. That's what the defendant's actions are boiled down to on July 4th of 2020. How do we know there were 2 or more conspirators? You've got video evidence. You've got video evidence from angles everywhere. You've got 3, 4, 5 people at the barricade at times. You've got the defendant shooting with 3 of the people he had been guarding the barricade with through the evening of July 4th. You've got the examples of an agreement with the aggravated assault that was incurred on the McCourts. You've got McCourts leaving. You've got 1, 2, Mr. McKinney, 3 individuals with guns, all working in tandem, all following the fleeing McCourts. All an example of an agreement by 2 or more conspirators. What the agreement does not require is, as we've talked about, written, or it doesn't have to be written or oral. It doesn't have to be anything that necessarily has to be said. You don't have to write a contract with details. It can just be an understood thing where, like this situation, you stand at a barricade with your AR and you don't let people through. And you commit acts of violence when they don't submit. And the judge is going to talk to you about, and you're going to hear about the elements of all the crimes that you've heard in the indictment that were read to you at the beginning of this trial. She's going to talk to you about count 1, murder. She's going to talk to you about counts 2 and 3, which are felony murders. and the predicate offenses or acts for each one of those felony murders, that being the aggravated assault with a deadly weapon on Secoriea Turner, and then count 7, which is the criminal damage to property in first degree for the shooting of the Jeep that Secoriea was riding in when she was killed. You're going to hear about the aggravated assaults in counts 5 and 6 that Omar Ivory and Charmaine Turner experienced when their car was fired on, the same car they were traveling with little Secoriea. You're going to hear about count 8, possession of a firearm during the commission of a felony. And you're going to hear about counts 9, 10, 11, and 12, and then 17, 18, 19, and 20 about those specific charges involving participation in criminal street gang activity and the different subsections that the judge will read and tell you the elements as it relates to each one of those charges. Then you're going to hear about counts 13 and 14, which we talked a little bit about today, about the aggravated assault that the McCours experienced when they first encountered the barricade with guns being pointed and threatened because of the disrespect they were showing for beginning to travel through the barricade, and then the aggravated assaults that you actually saw that were committed on the video by this defendant and Jerry McKinney when they were pointing their firearms at both Mr. and Mrs. McCord as they drove away. And the judge is going to tell you that with every one of the crimes in this indictment, specifically murder, intent is an essential element of any crime that must be proved by the state beyond a reasonable doubt. You may be shown in many ways provided before you, ladies and gentlemen, by facts and evidence from the witness stand, from physical pieces of evidence that are entered during the course of the trial from different witnesses, and you may infer from the proven circumstances or by acts and conduct, or it may be in your discretion infer what is the natural and necessary consequence of the act. So what does that mean? The natural and necessary consequence of pointing your AR-style rifle and pulling the trigger at least 8 times as a car, in this instance, a Jeep, where Secoriea was seated in the back, just playing on her phone, watching TikTok, that when you fire that weapon, that high velocity rifle into that vehicle, the natural and necessary consequence, it's going to hit somebody. It's going to hit the driver. In this instance, it could hit Charmaine, and in this instance, it did hit Secoriea Turner. And the natural and necessary consequence of getting shot with an AR-style rifle is death, is murder. It does not mean the intention to violate the law or to violate a criminal statute. It means simply the intention to commit the act that is prohibited by the statute. The state must prove that this defendant caused the death of another person, here, 8-year-old Secoriea Turner, unlawfully and with malice aforethought. The judge is going to talk to you about what that very antiquated term malice aforethought means. Malice is not necessarily ill will or hatred. Rather, it's the unlawful intent to kill. You may find malice in the circumstances show that this defendant acted with deliberate intention to unlawfully take the life of another person, to deliberately fire his high-velocity rifle into a car that's carrying 3 people that led to the death of Secoriea Turner. The judge is also going to tell you that malice can be shown where there does not appear to be significant provocation, and all the circumstances show what is called an abandoned and malignant heart. What does that mean? It means you have no regard for human life. And that's exactly what you saw in this instance. When you take your gun and fire your rifle at least 8 times at an unsuspecting car, that's what we call an abandoned and malignant heart. That's when you take someone's car, throw it on the ground, and you stomp on it. That's all it is. It's when you have absolutely no regard for human life, when you have absolutely no regard for a little girl who's just trying to get home to play with her cousins. The judge is going to tell you that murder, the state doesn't have to prove premeditation to prove murder. If the killing is done with malice, it is murder regardless of how brief the malicious intent existed There's no specific length of time. The judge is going to tell you it can be formed in an instant, in a moment. That if malice was in the defendant's mind at the time of the act or the killing, and moved the defendant to do so, that's enough for the killing to be murder here in the state of Georgia. The state does not have to prove motive. I would submit to you, ladies and gentlemen, there was motive. The motive was clear. It was the defendant and his members of his illegal barricade militia felt disrespected, and because of that disrespect, they just opened fire on the vehicle that Secoriea were just riding home in. The judge is also going to tell you and give you the elements of felony murder. And felony murder, you can find it in counts 2 and 3. And with felony murder, there's always going to be a predicate act. In this instance, the predicate acts are aggravated assault and criminal damage to property in the first degree. And the judge is going to tell you, unlike malice murder, felony murder, no proof of malice is required. You don't have to show you express or implied malice, we just talked about. There's no intent to cause the death. That's not required. What's required is that if the death occurred while the defendant was engaged in the performance of a felony act, an aggravated assault, criminal damage to property in the first degree, shooting into that vehicle, and someone dies as a result of it, that's felony murder. Again, that's the natural and necessary and expected consequences of an act, such as the one that this defendant committed on July 4th of 2020. And again, the predicate acts are aggravated assault and criminal damage to property. The judge is going to tell you about what aggravated assault with a deadly weapon is. Pretty straightforward, self-explanatory for once. It's an assault with a deadly weapon. The judge is going to say that as a matter of law, a firearm, a rifle, a handgun, things of that nature are considered a deadly weapon as a matter of law. To constitute an assault, actual injury need not be shown. The evidence only must show that the defendant attempted to commit a violent injury to the person of another. As it relates to little Secoriea Turner, her mother Charmaine, and Omar Ivory, we have both. We obviously have a devastating injury caused to Secoriea that ended her life. But then you have no injury, but obviously the intent to provide that violent injury was there and provided as it relates to both Charmaine and Mr. Ivory. They just got lucky. They survived. You're also going to see 2 counts, counts 13 and count 14, with the very same charges, very same elements as it relates to the McCords, Samantha, and Christopher. And as you saw on the video, after that distinct clothing was seen in the martyr video, and as Detective Shepard described, black do-rag, twist, red shirt, white lettering on the shirt, AR style, firearm, black satchel, light pants, and a light-skinned individual. 8 identifying characteristics that he looked for painstakingly in every video, in every second of every footage he watched. Now, the judge is going to tell you about criminal damage to property in the first degree. Exactly what it sounds like it is. It's knowingly and without authority, interfering with somebody else's property, and while doing so, you do it in such a manner that you endanger human life. Pretty straightforward. Take an AR rifle, fire it into a Jeep, in this instance, endangering the lives of everybody in that vehicle and ending the life of Secoriea Turner's. Shooting that vehicle all on the driver's side 8 times. Shoot at the driver's side back. The judge is also going to talk to you about possession of a firearm and the commission of a felony. Again, not a mystery. The state must prove that the defendant had a firearm on his person or within arm's reach of his person while committing. The judge is going to tell you at least one of the following acts we talked about here today: murder, felony murder, aggravated assault with a deadly weapon, as it relates to both Ms. Turner Mr. Ivory, and then McCord's, and then criminal damage to property in the first degree, where the defendant was using his rifle, as he described in his video that you saw during the testimony of Special Agent Coleman, in a berserk way, as he took that gun and fired it 8 times at Charmaine's Jeep. And here is just some photographs of the defendant with his firearm as he's committing the aggravated assaults against both Mr. and Mrs. McCord. Showing the defendant in the exact same clothing that Detective Shepard described that you just saw in a different angle. Still holding that firearm during the felonies just described. And the judge is going to talk to you about the remaining counts 9, 10, 11, and 12, and then 17, 18, 19, and 20, which involve the violation of the Street Gang and Terrorism Prevention Act, the gang counts, and the indictment. The judge is going to talk to you about each one of the subsections, subsection A, B, and then subsection E. You're going to hear about the elements of each one of these counts as it relates to what's required for subsection A, what's required for subsection B, and what's required for subsection E. The judge is going to define and give you information as it relates to participation in criminal street gang activity and what that means. The judge is going to tell you that person commits the offense of the violation of the Georgia Street Gang Terrorism and Prevention Act, the gang count, when that person, while associated with a criminal street gang, the Pyru Bloods, commits a crime that constitutes criminal gang activity. What's criminal gang activity? In this case, the judge is going to tell you it means commission, attempted commission, or conspiracy to commit, which we talked about, any offense that involves violence, aggravated assaults, for example, murder, felony murder, and the possession of a weapon or use of a weapon. And here, like we just talked about, murder, felony murder, aggravated assault with a deadly weapon, criminal damage to property in the first degree, and possession of a firearm during the commission of those same certain felonies. The judge is going to tell you, you are to consider criminal gang activity. She's going to talk to you about the tools that you are to utilize when you go back to, during deliberations and how you are to consider how criminal gang activity can be shown. The judge is going to tell you that the commission of any offense that would constitute criminal gang activity by any member or associate of an alleged criminal street gang, here at the Pyru Bloods, and that you are able to make that determination as it relates to whether there's the existence of a criminal street gang and criminal street gang activity by looking at those offenses, by utilizing the information that was provided by Special Agent Coleman, the information that was provided by this defendant and his Instagram as it relates to his membership and association with the Pyru Bloods. The judge is going to tell you for the subsection A counts 9 and 17, that the state must show beyond a reasonable doubt the existence of a criminal street gang, here the Pyru Bloods, that the defendant is associated with that criminal street gang, the Pyru Bloods. He told you that in his own words and what Special Agent Coleman described as his autobiography, outlining his gang membership not only in the Pyru Bloods, but in the G-Shine sect of the Bloods prior to that. And then the judge is going to talk to you about that the defendant committed or participated in criminal gang activity, and that the state showed a nexus or connection between the crimes that were committed, the aggravated assault, the murder, the felony murder, and the interest or furthering the interests of that gang. And here, as Detective Coleman talked about during his testimony, was clear that the acts that were committed, the acts that killed Secoriea Turner, were all due to the disrespect that was shown to this defendant and the members of his gang. That they didn't stop, they didn't bow down, they didn't submit to the authority of this defendant on July 4th, and they paid the consequences for it. It's as simple as that. She's going to tell you for counts 10 and 18, which is subsection B of our Gang Act, that the state must show the existence, again, of the criminal street gang, that the defendant is, again, associated with that criminal street gang, and that the defendant participated, again, in criminal gang activity. And he did all of that in order to maintain and increase his status or position in the gang. And you heard from Special Agent Coleman about how one increases and maintains the status or position in their gang. It's not about rank, he told you. It's not about things of that nature. It's about doing things in a highly visible manner. And because of that, you gain respect. You put in the work, and people watch you put in the work. It's the way Special Agent Coleman described it, which is exactly what happened here. This was, as we heard from Ms. Salloway yesterday, this was a crowded area. It had been crowded since the death of Rayshard Brooks. I think she said she started going to that location at University and Pryor the very next day on June 13th. And then from June 13th on, it was her core, I think she said 10 to 20 people, and then every day hundreds of other people showed up to protest and support the movement as it relates to the social injustice, as she described, for George Floyd and Rayshard Brooks. And at some point, this defendant took that movement over. That on July 4th of 2020, this defendant and the members of his armed militia took that movement over and turned it into a deadly celebration on the 4th of July. It's as simple as that. And did that in front of all of those people, as you saw in the video, and as was described by Detective Shepard, as was described during Special Agent Coleman's testimony. And then lastly, counts 11, 12, 19, and 20, which are your subsection E of our Criminal Street Gang Act statute. Again, the existence of a criminal street gang, that the defendant encouraged another to participate in criminal gang activity, and that the defendant was at the time an associate of the criminal street gang here, the Pirate Blood. The judge is going to tell you that as it relates to the term participate, that it means to take part in something, to share in something. Clearly, they were all taking part and sharing in the blocking of this road, the prevention of citizens being able to travel freely about the area of Pryor and University. It's not complicated as it relates to the elements of this crime because of the obvious nature and the in-your-face ways that this defendant and the members of his wannabe militia acted on July 4th of 2020. Acted unknowingly that it was being recorded by the local businesses and areas around, thinking that their dominance wasn't going to be collected by video evidence, that they would be able to continue to dominate that area without any consequence, without Detective Shepard being able to go through the hours of footage to find his distinctive clothing. The judge is going to talk to you also about what a criminal street gang is here, as you learned through Special Agent Coleman. The existence of a criminal street gang may be established by evidence of a common name, the Pirate Blood, the Bloods, and the signs and symbols, tattoos, the graffiti, and things of that nature, attire that gang utilizes and advertises with to get their customs and behaviors out to the members of the public, and here out to the people at Pryor University, and the fear that they wanted to spread that evening. Some examples that Special Agent Coleman described as relates specifically to the Pirate Bloods. At nauseam, he talked about the red color, the red attire, red tattoos, things of that nature, the 5-point star, and the red accents in the tattoo. The Elm Street reference, the 700 block reference, the 365, the anniversary for the members of that gang, red bandanas. And he described the distinctive characteristics of not Bloods, but the Pirate Bloods, that their distinguishing and distinctive characteristic is their violent ways in which they spread their dominance, in which they assert their authority, which is exactly what you saw on July 4th of 2020. Nothing different, nothing unexpected. And I was thinking about an example as it relates to the defendant's tattoos. You heard on the cross of Special Agent Coleman about the ice skate tattoo that was across the defendant's hand. And you heard a number of questions from defense counsel, Mr. Hoover, about this ice skate and what it means and its company and things of that nature. And all of that may be very true. And you heard Mr. Hoover talk about some characteristics that I think he said he had a 5-point star tattooed somewhere on his body, and then he talked about his family from Chicago, and I couldn't remember the last thing that he said as it relates to trying to compare the defendant's ice skate to the use of ice skate on his hand, and then the use of it along with other gang characteristics in his Instagram. But I was thinking, Mr. Hoover's exactly right. So the fact that he has a 5-point star, that he's from Chicago, I think he said his dad's name is, I can't remember, or his last name is Hoover. That doesn't make him a gang member because he's got a 5-point star and he's from Chicago. And the last characteristic he said, because he doesn't incorporate that, or he doesn't use that in conjunction with gang activity. He doesn't use that to advertise gang membership like this defendant did. He would write I skate with mob. He'd write I skate and then put, Elm Street block 700. I mean, that's the point. I have a 5 on my wrist. It means nothing but 5. But if I was to put that 5 on my wrist up on a photograph next to Elm Street Bloods, well, you're sending a message. That's the point that Special Agent Coleman was making. Not that everyone who has a 5-point star, everyone who has a red, 5 on their arm, or a tattoo that could be considered, a gang identifier, is a gang identifier. It's what it's used in conjunction with. It's the behaviors, it's the language, it's the message that you send along with your tattoo, which is exactly what this defendant did throughout his Instagram. He talked to you about some of the graffiti that he saw in relation to the area at Wendy's where Mr. Brooks was killed. He talked about the identifiers as it relates to Mr. Brooks being a member of the Pirate Bloods, and that being the purpose and why the members of Pirate Bloods gathered in this area, and the things that he saw. Then he talked to you about what we just referenced, some of the common signs and symbols of members of the Pirate Bloods, all found in the defendant's Instagram states Exhibit 153. Talk to you about those hand signs and what they mean, the message and the significance that they are to the members of the Pirate Bloods and this defendant, Julian Conley. He talked to you about each one of these hand signs and why it was important to his analysis. That this defendant was a gang member, this defendant used his gang membership to commit criminal acts. Why the tattoos on his body were significant as it relates to his ultimate opinion and conclusions. We talked about the background of not only the Bloods, but specifically the Pirate Blood set, and how and why it's a criminal street gang. We talked to you about this defendant, as he referenced his autobiography, and as you can see, admitting he was a pirate of blood. Before he was a pirate of blood, he was in G-Shine, sex and bloods, and it's not something somebody sent to him. He told him his autobiography because he's the author, ladies and gentlemen. He is sending that and letting whoever he's sending it to know his affiliation and his background. The judge, as we talked about, is going to talk to you about the use of firearms, the possession of firearms, and how that relates to criminal gang activity. We saw firearms all throughout this defendant's Instagram, having, needing, and his want for the fact.
Nigga, keep a gun. I keep a Glock G-locked in my back pocket. Pocket rocket, let it pop it, let it go berserk. Blood stains on my shooting on my t-shirt. Said the nigga moving pounds, but it's heat work. Yeah.
That video, and I played it a couple times with especially Coleman. I wanted to play it again for you, ladies and gentlemen, today, because that video describes exactly what this defendant did on July 4th of 2020. He used his gun, and as he described, he let it go berserk, so he could get stains of blood on his shirt. And on July 4th of 2020, the stains, the blood on his shirt was of an 8-year-old child. An 8-year-old child. 8-year-old Secoriea Turner. Again, there's more photographs, firearms. After the incident, this defendant is seen again a few hours later. Same shirt, same satchel, same firearm. And ultimately, Detective Coleman, or Special Agent Coleman, talked to you about the circumstances surrounding why this defendant was there, why members of his gang were there, why that territory was important to the Pirate Bloods. And they engaged in this pattern of criminal conduct, that they were blocking the roadways, that if you didn't submit, that you were threats of violence, and actual violence was imposed upon you for not submitting to their authority. And then lastly, as it relates to subsection E, the judge is going to talk to you about, again, the existence of a criminal street gang being required, and that the defendant encouraged another to participate in criminal gang activity, and that the defendant was at the time an associate or member of the criminal street gang, here the Pirate Bloods. What do we know about July 4th of 2020? We know this defendant was asserting authority with members of his gang. He was doing so he could control the area of Pryor and University, that people would submit the power and the authority that he exhibited and exuded, and if he didn't, it was, in his eyes, disrespect. And anyone who disrespected him we either met with violence, threats, and in this instance, death. Little Secoriea Turner died because her vehicle just attempted to go home. Little Secoriea Turner died just because she wanted to go play with her cousins. And if that wasn't convenient for this defendant. Now, in a moment, I'm going to sit down and the defendants will have an opportunity to address each and every one of you. And then Ms. Young will have an opportunity to go through all the facts and circumstances from July 4th of 2020 and everything that you heard as relates to the testimony